I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of James Dennis Whitley.
This is people's emergency motion to modify violence in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client.
Call her to show up to do what?
Today, to say I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. The court's going to stand in recess.
All right. 13A District Court for County, Washington, session, the Honorable Judge Simpson.
You may be seated. Court recalls the case of the people versus Whitman.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with on behalf of Mr. Whitley, who's standing to my right. Mr. Whitley, can you state your name before, please? James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it, because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all.
Your Honor.
That is all. Noon tomorrow. Happy. All right. They're bringing him.
And this may be the most important statement of the entire hearing. The judge says she does not make decisions out of anger. That distinction matters. A heated courtroom exchange can make it feel like emotions are controlling the case, but the judge is deliberately separating the attorney's conduct from the defendant's fate. She schedules the matter for the next day, orders everyone to appear, and keeps the proceedings moving. So after all that courtroom fireworks, the real battle isn't over. It's simply been postponed until tomorrow.